Oh, okay. And then you watch, and then I know what
Hi, good afternoon.
Hi, leadership was off.
I could see here.
Well, you're gonna go one up.
I don't know if everybody can sit on one. But look, this up there for the presiding justice. So if you're the justice, you got it.
I don't preside.
Oh, okay.
We near.
You.
Testing, testing. Yes, it's fine.
You're fine.
Good afternoon, everyone. Good afternoon. I'm Ansori Manuel. I'm the Secretary of the Judicial Education Institute. And I'd like to welcome everyone this afternoon to the JI's training session, Unpacking the New Justice of the Peace Regulation. Today, You will be learning a lot about the new Justice of the Peace regulations. And we will begin with an opening remarks by the Honorable Chief Justice, followed by presentations by Mr. Ariel Mr. Peace Counsel and Mr. Ricardo Donhu Gardiner, who's a presiding Justice of the Peace. They are both attorneys at law and have extensive practice as attorneys at law and as justices of the peace. We thank you all for being here with us in person and virtually. I will now ask you all to stand as the Honorable Chief Justice enters the court. Thank you.
Yeah. The facilitators. The Chief Magistrate, Mr. Julian Hetman, the Registrar of the Magistrates Court, Ms. Patricia Arana, the facilitators of the Judicial Education Institute's Training of Justices of the Peace, Mr. Ariel Missick, King's Counsel, and Mr. Don Hugh Gardner, Presiding Justice for Providencialis, the former Premier of the Turks and Caicos Islands and Justice of the Peace, Ms. Charlene Cartwright Robinson, Justices of the Peace of the Turks and Caicos Islands and aspiring Justices of the Peace, good afternoon. May I thank you for coming, and may I welcome you to this training session, which seeks to bring home to every Justice of the Peace the current legislative and administrative regime governing Justices of the Peace in these islands. In the third quarter of 2021, began a number of meetings held by His Excellency the former Governor, the Honorable Attorney General, and myself to discuss a more effective administration of the Justices of the Peace in these islands. The outcome of these discussions was that the Chief Justice was tasked to streamline the administration of justice, of the Justices of the Peace, including delivering an administrative regime to govern the appointment, tenure, and the work of Justices of the Peace. Pursuant to these matters, 3 amendments have been made to the Magistrates Court's ordinance to provide a framework for appointments, disqualifications, removals, suspensions, reappointments, the powers of Justices of the Peace, the training of Justices of the Peace, and the roll and register of Justices of the Peace. Subsidiary to this, the Justice of the Peace number 2 Regulations 2023, which provide clear terms of reference for Justices of the Peace, have now been introduced. They are the subject of today's training. Following the said enabling legislation, the judiciary of the TCI, as part of its mission to provide access to quality justice, now embraces the administration of Justices of the Peace within its remit, working in tandem with the Office of the Governor, the Registrar General, and other stakeholders. In the new regime, applications for appointments or reappointments to the office are lodged with the Registrar of the Magistrates Court. The Registrar compiles and keeps the register mandated under the regulations. She also assigns the identification numbers of Justices of the Peace and provides the approved stamps for the work of justices of the peace. Every justice of the peace is to be supplied with 2 judiciary-issued stamps for the conduct of business. The first is the stamp of office, which is the JP stamp. The second is the certifying stamp for certifying documents. At this time, the judiciary has taken delivery of 45 JP stamps. We await the rest. We have also taken delivery of 10 certifying stamps and await what we have been assured will be produced in short order. I respectfully request that all justices of the peace here present, whose stamps are ready, provide their signatures above their stamps. We will scan and lodge them with the Registrar General, the Registrar of Lands, and any other place where a justice of the peace work is required. After we have informed all registered justices of the peace that their stamps are ready for collection, we shall, following a reasonable period during which justices of the peace are expected to attend the registrar to collect their stamps and provide their signatures, advise the Registrar General and the Registrar of Lands and all our stakeholders not to accept any document without the authorized stamp and the signature supplied by the judiciary to them. May I respectfully emphasize this deadline. Now, may I formally introduce you to the registrar in charge of the administration of the Justices of the Peace, Ms. Patricia Arana. Ms. Arana, who is also the registrar of the Magistrates Court, also chairs the vetting panel, which investigates issues pertaining to appointments and the tenure of Justices of the Peace. She serves with Mrs. Skippings Reynolds, the Executive Director of the Office of the Governor, and Ms. Keon Cox, the Registrar General of the Turks and Caicos Islands. May I also formally introduce to you the disciplinary panel, which is chaired by Her Honor, Mrs. Oreka Salva-Gardner, Resident Magistrate of Providenciales, and has Ms. Patricia Arana and Ms. Angela Musgrove, Chief Executive Officer of Invest Turks and Caicos, as its members. Their findings will be implemented by the Chief Magistrate, His Honor, Mr. John Leon Hartman, who is vested with disciplinary powers. Finally, I thank our facilitators for this training, Mr. Ariel Missick, KC, and Justice of the Peace, and Mr. Ricardo Donhue Gardner, Presiding Justice of the Peace of Providenciales. I am in no doubt that you will find the training session both engaging and insightful. I thank you for your attendance today and for your attention. And once again, I say, this is the judiciary of the Turks and Caicos Islands. We serve with excellence. Thank you.
Thank you. Good afternoon again, everyone. We now move on to the second part of today's seminar, which is the actual seminar, the training by Mr. Ariel Missick, King's Counsel, and Mr. Ricardo Donhue Gardner. Please welcome them. Thank you.
Good afternoon. It is our honor and pleasure to be able to give this first training session on the role and responsibility of justices of the peace in these islands. The topic for today's training is unpacking the new Justice of the Peace regulations. But before we get into the new regulations, I think it is useful to remind you of the powers and functions that you have as justices of the peace. Those functions derive from the Magistrates Court Ordinance, and in particular, Section 19I. They also derive from other statutes which require certain documents to be certified by a justice of the peace, and from other ordinances which require certain documents to be sworn before a person who is authorized to administer oaths. And one of the functions of a justice of the peace under Section 19I of the Magistrates Court Ordinance is that of administering. One of the powers you have is the power to administer oaths. It is important to know that you have no power to do anything other than those conferred upon you by Section 19(1) or by the regulations. And if you are requested to do something which falls outside those powers, you are acting outside of the law, and you should refrain from doing so. So Mr. Gardner and I have agreed that we will separate the presentation. He will deal with those powers and functions which relates to the powers normally exercisable by a magistrate's court in connection with court proceedings, such as receiving complaints, signing a charge, issuing arrest warrants, such warrants, and so forth. And I will deal with the more mundane functions that most of you perform on a daily basis or more regular basis, is that of certifying documents or persons. For example, if you are certifying a passport picture of someone who is applying for a passport, or if you are certifying that a document is a true copy of the original, or if you are signing a transfer of land, which has to be registered at the land registry, or if you are swearing an affidavit in connection with proceedings before the court. So I will start off first by dealing with the requirements for certifying the identity of a person. And this is regulated by Regulation 7 of the regulations. And under that regulation, you may only certify the identity of a person if you have personal knowledge of that person, or if you can identify that person by an approved government-issued identification. If you are relying on your personal knowledge, you must see the person's face, unless there's a genuine medical reason for the person wearing a face covering. A person's face is the area between the forehead and the bottom of the chin. But it excludes the ears. So you can say if you're not able to see the ears, then that's okay, but you're able to see the face. Then a face covering would include sunglasses, a hat that covers the forehead, but it would not include a scarf that covers just the hair. So the only circumstances in which you can identify a person by his face without seeing the face is if there's a genuine medical reason for doing so. And an example of a genuine medical reason would be if the person is wearing a mask during a pandemic, or for example, if there's an obvious injury to the person's face. religious or cultural reasons for wearing a face covering is not a good reason. If you are relying on a government-issued document to identify the person, you must be satisfied that the document is genuine and that you understand the nature and content of the document and that the document is true and correct. If you're required to certify a document, a copy of a document as being true, you must have both the original and the copy document in front of you. And you must satisfy yourself that the original or the document presented to you as the original is in fact the original document. If the person presenting the document to you tells you that it is the original, and if you examine that document and you have no reason to disbelieve it, then you may accept that. But if you look at the document and it is obvious to you that it is not the original, then you should not certify the document. You should not certify the copy as being a true copy. And neither can you certify it if they present to you a certified copy. You can't certify a copy is true by looking at a certified copy. So here's the steps you should follow. Carefully compare the original to the copy that is presented to you to make sure that it is the same. Another way of doing that is by either making or watching a copy of the document made in front of you. If you are satisfied that the document that you are certifying is a true copy of the original, then you add your certification to the document, either by writing it or by imposing your stamp. And you've just heard from the Chief Justice that everyone would be issued with a stamp. So you attach your stamp to the document with your signature. If the document has more than one page, then it is only necessary for you to stamp or certify the first page. And if the stamp presumably will contain your name and qualification, that would be sufficient. If you don't have a stamp, or if the stamp does not contain your qualification, you should add that to the document, and then you sign the certification. So that will complete the process of certifying a copy of a document. Now, the regulation does not speak to an electronic, a document which is an electronic form, the original of which is an electronic form. I would suggest to you that in order to certify to certify a copy of an electronic document as being a true copy of the original, you can only do that if three conditions are met. First, if you saw the paper copy printed from a website under the control of the issuer of the document. Secondly, if you saw it printed directly from a computer or other device under the control of the of the authority that's issuing the document. And third, if the electronic original is displayed in front of you on an official website under the control of the authority issuing the document. And the one thing you may not do is you may not certify your own personal document or that of your family. You should go to another justice of the peace to do that. And the reason for that is that may lead to conflict of interest. And as we will touch on later in this presentation, you must avoid putting yourself in a position where there is an actual or a perceived conflict of interest when signing or certifying documents. The next function that I will address is that of witnessing a document. We just dealt with identifying a document identifying a person, and then certifying a copy. Sometimes you're asked to witness a document. For example, a transfer of land to transfer land from A to B. So here are the steps which you should follow when witnessing a document. First, check to see that it's a document that you have the power to witness, because not every document authorizes it to be witnessed by a justice of the peace. But assuming it is one of those documents that can be witnessed by a justice of the peace, again, you need to see the person's face. And you must follow the same procedure by making sure that he does not have on a mask, or if he has one, or any kind of face covering, that those are removed. Next thing you do is you identify the person's identity. You satisfy yourself of the person's identity, and again, you do that in the same way as we spoke about before. You must do so either if you have personal knowledge of the person, or if you have in front of you an approved government identification or a certified copy of that document. You must look for blank spaces in the document. If there are blank spaces which needs to be filled out and they are not filled out, you should not sign, because after you've witnessed the document, someone can go in and insert information in the document, and then you would have said that you certified and you saw that person sign that document with that information in it, which would not be the truth. If the document contains annexes or attachments, make sure they're all attached at the same time that the documents are presented to you for witnessing. And then you must also check that the person who is signing the document has the mental capacity to execute that document or document of that nature. So then you may say, well, how will I know that? I'm not a doctor. I can't tell when someone has the mental capacity or not. But there are certain things you can do to satisfy yourself by asking the person a certain question. For example, you may ask the person, what is the purpose of this document? And if the person cannot give you a reason, cannot tell you the purpose of that document, then there's a problem. Or you may ask the person, why are you signing this document? And if they have no reason to tell you why they're signing the document, again, there's a problem, and you should not witness the document. And once you are satisfied that the person has the capacity, you've identified the person, then you add your signature to the document and print your name and qualification, or attach your stamp. The next document you are maybe asked to witness or to sign is that of an affidavit. An affidavit may be used for various purposes, including an affidavit which is sworn in connection with court proceedings, or for example, it may have to be sworn in connection with an application for letters of administration. And then you approach it in the same way as if you were witnessing a document. You go through all of those steps I've just outlined, but there are additional steps that you have to take in the case of an affidavit. And if you want to know whether or not the document is an affidavit, most times it would actually say so on the face of the document. It would say it's an affidavit, so you know it's an affidavit. And before the person signs the document, after you've gone through all the checks, you've checked the identification, you've checked that they know what the document is about, then you must administer the oath. And there's an oath that will be at the bottom or somewhere on the affidavit. And you must ask the person to actually repeat the oath in front of you. before they sign the document, and only after you've administered the oath, they've said the oath, and they've signed the document, should you attach your signature and your stamp. If the person cannot read, then what you must do is you or someone else in your presence must read the whole document in front of the person to whom you are administering the oath to, because the person is actually saying before you that the contents of the document are true. And if they can't read it, then and they're not told what's in it, then there's an issue as to whether or not, when that document is presented, it is the truth. And there's one other very important matter in connection with an affidavit, which you ought to bring to the person's attention, and you should do this before they sign. Although the regulations do not speak to it, it is the position that an affidavit, a person who swears an affidavit in connection with legal proceedings, that is the same as if you were actually in court and you were giving evidence, oral evidence in court. And if you lie while you are giving evidence in court, you commit the offense of perjury. And so if the person swears an affidavit and they lie in the affidavit, they also commit a perjury, the criminal offense of perjury. And so it is useful to remind the person that if they say something in an affidavit and what they say is untrue, they may be committing an offense and liable to prosecution. That's what I wanted to tell you about how you proceed about going about executing documents and witnessing them and so forth. There's one other matter which I would like to address before I turn it over to Mr. Gardner. Well, two matters. First of all, just to go back a little bit, if the document that you are witnessing is not in English, then there must be a translation, an approved translation of it before it is witnessed or executed. The other matter which I wanted to touch on is the question of the code of conduct, which is attached to the regulations in Schedule 2. This is very important, and it's important that you read through it thoroughly because it may have consequences for you. And I think it's important that you're aware of these elements of the code of conduct. First of all, and this may or may not come as a surprise to some of you, but you cannot charge a fee for your services, directly or indirectly, or accept any kind of reward for performing your function as justice of the peace. You cannot use your position as justice of the peace to advance your own business or commercial interests or to further any political activities. And as I said before, you cannot exercise your function, when to do so would put you in an actual or perceived conflict of interest. For example, let's say if your brother or your uncle was a party in court proceedings and he asked you to swear an affidavit on his behalf, to witness an affidavit on his behalf, you should refuse to do that because that would put you in a position of conflict. And then there is this, which is extremely important for all of you to know. Paragraph 5 of the Code of Conduct imposes a duty of care on justice of the peace and a legal obligation to take reasonable care to avoid causing harm to another through your actions or omissions, to act honestly and carefully, and to follow any instructions in the document you certify as to the person's identity or in affidavits. And for those of you who are non-lawyers, the use of the words duty of care, that means something. It means if you do not comply with your duty of care, you can open yourself up to civil liability. You may be sued. If a person suffers a wrong or damages as a result of your laissez-faire or negligent approach to the exercise of your function. So for example, let's say someone comes along and you certify this person's identity, and it is not that person. And as a result of that, a third person incur a loss because they think they're dealing with AB, when in fact they're dealing with CD, and you certify to them that they're dealing with AB. And if they suffer loss, they can bring proceedings against you for negligently. Now, obviously, if you take all of the precautions that you're supposed to take, and you still misidentify the person, then that's fine. But if you pay no attention, if you just simply, turn your head this way and sign and say, well, this person is AB, when in fact he is CD, you open yourselves up to liability. So, and then the last thing which I should bring to your attention is that you are not to give legal advice. The role of the justice of the peace is not to give legal advice to anyone. And so it is conceivable that someone may come to you and say, well, ask you a question which goes beyond your function and which goes into the realm of legal advice. You should decline to offer any kind of legal advice. So those are the points that I wish to bring to your attention. And if you have any questions after we hear from Mr. Gardner, I'll do my best to answer them. Thank you.
Good afternoon, everyone. So, the concept of a justice of the peace owes its origin back to 1195, thereabouts, during the reign of Richard Lionheart. At that time, he thought it best to help to assist him in keeping the peace in the unruly parts of England, that he would appoint knights, the keepers of the peace. And after many years, that became what we know today as justice of the peace. Now, justice of the peace in this jurisdiction has a tremendous amount of authority to have a person's freedom taken away from them, signing an arrest warrant, the authority to have somebody's home or business or any other property searched, signing a search warrant, the authority to sign summonses requiring them to appear at certain places at certain times, do certain other things. These are all authority that is given through Section 19I of the Magistrates Court Code. It says that justice of the peace respect of these circumstances have the same authority as magistrates. Now, it also says that in certain cases, justices of the peace would have the authority to also try and determine certain cases. But that is restricted to the time of your warrant at authority. Last person I knew, last JP I knew who may have had that authority, certainly. But did not recall. Now, there are certain functions of JPs that are also in addition to what is settled in the magistrate court. As Mr. Mizik mentioned, there is legislation, like, for example, the landlord gives you the authority to witness certain documents, and certain other documents, authority to keep oaths, and the liquor licensing ordinance gives you, makes you a member of the liquor licensing authority district that you are resident in. But the autonomous function. So we talk about magistrates having the authority to give warrants, issue summonses, to determine and to sign complaints and charges. So the obvious question is therefore, what is a warrant, or what is a summons or complaint or charge? I'll do my best to say what I think they are in as few words as possible. The warrant is, generally speaking, an order that serves as a specific type of authorization. That is, it's a writ issued by a court or an officer of a court, usually a judge or magistrate, and in our case, justice of peace, that permits an otherwise unlawful act be done. Something that would violate or ordinarily be seen as violating some individual's civil right to be done without falling if that person performs that act based on that warrant. So you may have a situation where you have a search warrant where you, as a justice, sign a warrant issued to a police officer, ask them to go to a person's house and search for certain things. So on an arrest warrant, give with your signature that the authority of someone to detain someone. Right? A summons is a judicial notice served on a person who is involved in legal proceedings. Summons will typically announce to the person whom it is directed that an action has been started against him, that he must appear at XYZ place on XYZ date and produce with him when he comes XYZ items. So it's a direction, and someone is an individual come to court and be here at a certain time for this purpose. A complaint, I had a difficulty in making the distinction between a complaint and a charge in my mind, but I may have gotten it. A complaint is the first document that is filed in a court in a criminal case. This document will generally set out the reason why you're being asked to go. The reason why the Crown government believes that they are justified in bringing a case against you. And the charge is simply statement of the offense, of the part of the law that you have breached. And that will say, well, Mr. XYZ is charged with the breach of prevention of terrorism. So recognizing the constitutional guarantees relating to the peaceful enjoyment of one's home and liberty, and to be a free person exercising this normal constitution guaranteed right. When it comes to deciding whether or not you would want to sign or whether when someone puts a search warrant or an arrest warrant or something before you and asks you for your signature, it is important that you interrogate them, or certainly gather from them that they have probable cause to have you do that, have to do these things. Because a man's freedom is not lightly, nor is his home to be violated by probable cause. So you may wish to ask the person who is the police officer who's presenting you with the warrant signed, why? Is it something that you feel on a summon to appear to court, arrested and brought to court by the police? And there are other things you must satisfy yourself that I am justified in providing this person. Sometimes you may have, and certainly I've been in situations where from these officers because they thought of going far or not too much. And when I said to them that if I can't tell you that I can't satisfy, if I can't decide, simply go off and find someone else. That's stringent personal requirements. Who will take their obligation less seriously. Now, in doing these functions, you should also be aware that you look out for the conflict situations where the persons involved may be relatives of yours or business partners of yours or sworn and active enemies. And so in those kinds of situations, you consider that you cannot give a fair and impartial, unbiased decision as to whether or not to issue a search warrant or arrest. And you should say to the police officer, I am something. Whatever. You don't need that. I'm so those would be the areas where duties of the JP refer to powers as it functions as referred to in 19I. It's a very large room, and people in the back may want to have the benefit of the question and answers.
Yeah, yeah. It'll have to be the government department or the business. It has to be the website or a computer terminal of one of those. Yeah. So, for example, let's say, if you want to certify an electricity bill for Fortis, right? And let's say if that electricity bill is in electronic form, then you must be able to, and I don't know whether Fortis does this or not. I don't know whether you're able to do this. I don't know. But you would have to go onto the website. If this document is not displayed on the website of Fortis, then you can't that's not an original document which you can certify. Or if it's not, or if you can't log on into a computer and access it to a site which is controlled by Fortis, then you can't sign. Then the only document you can sign is an actual physical original of the invoice. Yes, yeah. No. You are a justice of the peace, and you have the power not your power. Your function not simply is to sign, but to administer the oath. And as a justice of the peace, you do have the power under Section 19I of the Magistrates Courts Ordinance. You have the power to administer oath. So, for example, if the person you take the Bible or whatever it is, and you make the person swear the oath that this is true. Well, what I can tell you about this is that if it is a contentious litigation, a lawyer who is a justice of the peace cannot sign a document on behalf of his own client, because that would be a conflict of interest. So for example, if we had a client and he's swearing an affidavit, then we have to send him elsewhere to another justice of the peace or to another law firm and get him swear. We can't swear the document. I'm a justice of the peace, and I see my partner in the back there, Gordon Kerr. He's a justice of the peace. He can't sign either, because that would be a conflict of interest.
Sorry, two quick questions for you.
Mhm.
One is following up on the current. What happens with Fortis bill is they will email it to account holder. So say, for example, Fortis email your bill to you. You then forward that email from Fortis to me as a JP. Would you say that is sufficient?
No.
For me to then, because I would not be receiving directly from Fortis.
No, well, even if you were to receive it directly from Fortis, that would not count, because it is conceivable, although not likely, that the email itself could be interfered with. So you can have someone in Fortis or someone outside of Fortis tampering with the email process. So no, an email document, a document that is received by email, is not an original document. It has to be one that you can actually see it on the website or a computer terminal, which belongs to the person issuing the document.
No, the right to marry someone or to conduct a ceremony of marriage for someone is covered by the marriage ordinance, and only persons who have been made a marriage officer or registrar of marriages. Some JPs are both, and some are.
The documents that I got started as the original were only coming to the cloud language and have a JP sign it as in the original. Look, I got it. That is something that has to be included as federal state. Having that experience, I heard enough. And they asked me to also sign documents.
Well, it would be up to the to that department whether or not they will accept something less than the original. So yeah. So if they are willing for a JP to certify something less than the original, then I think I would not certify a document which says that this is the original if I have not seen it. So I think they will need to adjust their system so that they don't put a JP in the position of saying something is a copy of the original when the JP is not able to see the original.
Anyone else?
Question.
Is this the magistrate's court ordinance you're looking at? Or the regulation? Okay. Right. Mm-hmm.
Of course, when I looked at section 7, it appears to me, and I hope I'm hoping that it's correct. If he asked to at least attend one of
Yeah. So you have to attend. There will be two, but you have to attend at least one. But you can, of course, attend both.
Sorry, one more question about the.
Mhm.
I know you spoke about making sure that a document doesn't have to be blank before executed at the JP. And that brings to mind transfer documents, which we love to have undated. Would you call that a significant blank? One that has to be something, or is that insignificant enough at the JP?
Well, I would say that was significant unless there is a provision, unless you are satisfied that there's some provision or some arrangement, some legitimate arrangement, which would allow for the date to be inserted afterwards. But I'd be.
Sorry, certification is normally dated, so the JP would only find this person appeared before me on blank page.
Right.
But on the front page, the act transfer, we would leave that blank.
Leave what? Leave what?
The date,
Yeah.
Why would you leave the date blank?
without paying penalty. And some, most times, people like that date inserted at the end, after the JP has certified.
Well, no, I wouldn't.
That's for the purpose of certifying the document. That is not for the purpose of witnessing. Is your point for the, because I can't imagine unless you are compiling an exhibit bundle or something, why you would even need a certified copy of a signed but not registered transfer.
No,
He's talking about witnessing.
No, I'm speaking the transfer document itself, and I don't want to be too specific, but the transfer document itself, if I'm selling property, has my certificate of identification on the back. The JP has to fill in that.
Well, I think Mr. Mizik's point was to a certification of a copy of a document, as opposed to signing a document. Because when you sign the transfer as a JP and you fill out the certificate of identification in the back, you have done your part. All I'm saying is that I've seen this person put his document.
Yeah.
Now the issue becomes
No,
how.
the point I was raising was only because it was pointed out that we need to be conscious that they're not significant blank. And I know that the date is often a blank, but it is one that is blank for me.
Well, I think you'd have to be a bit careful here because the whole purpose of the date when the document is signed and the date when it is presented for registration is a provision for, as you said, for the 30 days for payment of the stamp duty. And if the duty is not paid within the 30 days, then you incur a penalty, which is 3 times the amount of the duty. So I think you have to be careful not to be seen to avoiding the imposition of the penalty by leaving the date blank. So if I think that if the purpose of doing it is to allow the duty to be the penalty not to be imposed, then I think you're treading on thin ice there.
Mr. Walken.
Okay, so I think in the older days, they used to have this position of JP supernumerary, which was someone who was paid, who was getting a stipend. So that was one, but and then to separate that from someone who is not paid, who doesn't get a payment. For example, they used to have that in the case like of a magistrate. I think that was the origin of that. You used to have a magistrate who was actually appointed to perform a job on a regular basis and got paid for it. So, but I think that distinction is really not in use anymore.
The only distinction there is between the two is how they are appointed and potentially how they're removed. A regular member of the public applies to the registrar of the school to become a GP. A person who is in the public service applies to the governor. Once you've been appointed and received your warrant of appointment, you have the same functions, same authority, same beast, same burden, really. And it doesn't matter how you come to the appointment, as long as it's a lawful appointment. Not the same.
And no one gets paid for that position. If you're a public officer, you get paid by virtue of your position, but not because you're a supernumerary JP. That you don't get any extra pay for that.
So what is the other question, sir? Yeah. But a justice of the peace is a judicial, quasi-judicial function. A notary is a civil function. And so, whereas a justice of the peace must his certifications, and anything he does is recognized within his jurisdiction of influence, his jurisdiction that he's appointed to operate within. For example, if you are certifying a document or you are signing a document that is going to be used abroad, a JP's signature is of no use to you because it's a judicial document, quasi-judicial signature that cannot be apostilled. The International Convention dealing with apostille accept judicial signatures from being apostilled. Notaries can be. Notaries perform, by and large, the same function in the territory and outside the territory. And so your worth or your worth of your signature is the same whether it's home or abroad. In the case of a justice of the peace, it is only good at home.
So, let's follow up on that. So, the passport
Well, it can be signed by a JP because the passport ordinance says that it can be. The passport ordinance and the Passport Act of the UK basically says that these people in a Commonwealth country can sign. And in a Commonwealth country, i.e., can sign because the Passport Act says you can. And so you have that statute. But if you're signing an affidavit that is going to be filed in the Supreme Court in Jamaica, for example, you wouldn't want to do that. Doing that so you
The documentation, if that's presented before you, if it has, stands the front page, and the last page, or so facility, we talk about the front page, and there are amendments with, and also, as follow up that, we keep track.
Okay, so if it's an if the document that you're witnessing is an affidavit, which is sworn, the attachment there have to be exhibit. You have to swear an exhibit page, just the first page of the exhibit. If it's one exhibit, you swear the exhibit page, your document saying. You will say, for example, like this is the document that is referred to in the affidavit of so and so that I swore. You swear there's the exhibit. If there's more than one exhibit, then you do it as many times. So you have to swear 6 different exhibit pages. But you can all attach them as one document, or you can, if they're different series of documents, you can have different exhibits.
She's asking is if it's a contract, 20-page contract, do you sign just the front page, or you sign the last page? gives you obligation to sign everything.
Or see, no. Well, you don't have to sign every page, as long as you are satisfied that the document that is referred to in the affidavit is the document that's attached to it. Now, what most people do, and it's not the notary, it's the people who sign the contract. Sometimes they would initial each page to make sure that their document is can be identified. And as to your question as to whether or not you have to keep the document, the answer is no. But what you must do is you have to keep a ledger. Now, we didn't refer to this earlier on. Under Regulation 10 of the regulations, you have to keep a ledger in which you record every service that you provide. So, for example, if today someone comes to you and you witness a document on their behalf, then you must say, you have to have the name of the person and what is the nature of the service you provide, and where you provided it and where it took place. For example, did it take place at your house or did it take place at your office?
Alice?
Still point you made about signing warrant, continue and that will lead that's special access one to satisfy for signing.
Well, what I do when someone brings it to me, I would generally ask them if what is in their affidavit or the statement they sent in, if this is true and correct. I'll generally read through it myself, and one of the things I would also ask in the case of an arrest warrant, for example, is again, is this something that you can give an issue stuff when have them come before on Monday? Let's suppose arrest Friday afternoon or something like that. With an arrest warrant. Now, it becomes a bit, for me, it becomes a bit more difficult when dealing with search warrants, because I think you don't, I don't necessarily want, they say they need to search, and they set out in their affidavit the reason why they need to search. Basically, if you consider that is sufficient reason, then all of those things will be. I don't know that. I don't know that there's any specific things that I would look for. But as a JP, that's why I look for the affidavit. Any other reason, just how they can handle the situation without detaining someone, and if that can't be done or that's not reasonable in circumstances, then I'll go ahead.
I would think if it's a policeman or someone else who is asking for it, one of the things they have to do is they have to tell you that they have reasonable cause to believe that A, the document is there, B, that whatever they're looking for is relevant to the possible commission of an offense, and C, that there's reasonable apprehension that if the search is not carried out, then the documents or the whatever they're looking for might be lost to the investigation. So I think all of those things have to be, the affidavit must address all of those. In other words, it can't just say, well, I think an offense is committed and I want to go here and look for it. So you have to say, is there reason to believe that an offense has been committed? Is there reason to believe that documents relevant to that offense is in this particular location? Is there a reasonable prospect that the person or the place where the document is located will hide, destroy, or move those documents if a search warrant is not executed. So, I think the affidavit ought to address all of those. And so, if it's a policeman giving you those that information, unless either from reading the affidavit itself, you have some reason to believe that any of those elements have not been established. And I think obviously you're entitled to probe the person, and if your probing doesn't change their view or their perception of their reasonable cause, then I think you might be a little hard pressed to say no, because one of the obligations under the regulations, you can't unreasonably refuse to perform the function. You can't say, well, look, you can't say, for example, say, well, I don't believe in issuing warrants to policemen. That would be that would not be a proper exercise of your function. So you have to have a reason why you're not going to sign a warrant or issue a document.
The next training was on what would be a practical application for a warrant or you would appreciate what you hear it. You directly to it. That's one of the reasons why
That's not what I heard.
Yes. We'll deal with that.
Mr. Saunders? You're standing up?
Yes, Justice.
Oh, very well. Anyone else? Trump.
Everyone, I now hand everyone who vote. The registrar, Ms. Patricia, on give a vote of thanks. Before I do, I would ask everyone. Thank you. There are several copies of the JI attendance sheet. Should be one on each desk. We ask all the defeats and all attendees to please sign the attendance sheet. Thank you very much.
Good afternoon again, everyone. We saw that the protocol is being established by Madam President earlier. Thanks to Madam President for being a visionary and for being a driving force in regularizing and implementing the work. Thanks to our facilitators, Mr. Ariel, PhD, and Mr. Ricardo Johnson, for breaking down the relevant regulations and ordinances for us, and drawing special attention to some of the representatives. Taking from their presentations, I would like to share a list of 3 points mentioned: conflict of interest, powers of the procedures for the code of conduct, not to act outside the powers, not to deal with warrants. Your role is definitely not a rubber stamp role. This is a service that's provided free. I encourage you to read over the provisions of the regulations and the ordinance and the constitution And for attending this training, thank you for your question. I hope that the training was beneficial for you and you in better understanding your roles as a person. With regards to the stamp, we have the JP stamp, this person, name card. They have mentioned that we will get along with the certified stamp. Like, they stamp and certified stamp. Present your ID when you're going. The stamp will not- The stamp will be registered to the side of the report. You're required to sign above your stamp as required by the regulations. Thank you once again for attending.
Thank you. Everyone can please help yourself to some refreshment. Like refreshment. Thank you very much. Thank you. Excellent presentation.
Bye.